start with the recording, and okay. So of course, if you have any issues with the recording, just turn your camera off. I'm saying that for Donnie. I don't think Tommaso can do that. So just a quick introduction. I guess it's more for the viewers later on than for those connected today about Web3 Tuesdays. It's just a series of webinars, and the third event that we have today. And we address various topics related to technology and the law. And today we have Tommaso Ariani, who I know very well. He's a wonderful lawyer and a very experienced professional. He has now founded his own law firm in Florence, and he focuses on bankruptcy and insolvency in general. And he was previously working with Professor Stanghellini at his firm, and later as a partner at BASP law firm, still in Florence. But most relevantly for our discussion today, he is the bankruptcy trustee of one of the largest crypto exchanges in Italy at the time of bankruptcy. And well, today he will discuss the bankruptcy proceedings, of centralized crypto exchanges. And I think it's a real pleasure to hear it from someone who knows how it works in practice and has undergone the process from pretty much the beginning of it. So without any further ado, Tommaso, if you want to take the floor.
So first of all, thank you very much, Filippo, and everybody for inviting me and offer this opportunity to share my experience as a trustee of the Big Grade case. It's 20 minutes discussion, so I don't know whether I'll be able to cover all the topics and all the issues that were posed to me actually, and to my co-trustee, Mr. Dr. Gian Pietro Castaldi, who were appointed by the Court of Florence. By the way, he sends his regards. But I would like to browse through some of the issues which have arisen during the time I was appointed as trustee. So I think I will go. I will use the Big Grade case just as an example of what could happen in a exchange on a platform bankruptcy, basically. So with respect to Big Grade, there were two phases. There was the pre-bankruptcy phase, which lasted at least 7 months, in order to check whether the company was really insolvent or not. So and it was a very interesting part with respect to legal issues concerning bankruptcy of cryptocurrency platform. And in particular, the court had to face some of the issues that every time there is a bankruptcy of a platform are asked, such as who owns the cryptocurrency that are basically that are held over in the platform? Who is the owner? Is the platform or are the clients of the platform? This is a question which is essential in all the kinds of bankruptcy. For instance, in Mongox, which was the first bankruptcy of a platform in the world, this was a central topic, and the Japanese court decided that the assets were with the bankrupt platform. In Florence, they did the same. So at the end of a long litigation, which lasted 7 months and was basically concerned also with respect to this topic, the Court of Florence decided that the cryptocurrency were owned by the platform, so the Big Grade platform. What is very interesting for us are two things. First of all, is not true by definition that who owns your key, the keys owns the money. So this is not true by definition. I mean, there is always this sentence that we use: your keys, your money. So not your keys, not your money. But this is not true 100% under Italian law, because the Court of Florence had to found that the platform could use the money of the creditors, so of the clients of the platform. So basically, when she found that not only she had the keys, but she could use this key, then she decided that the assets were owned by the platform. So this is a very important thing, and I think in any jurisdiction it should be checked out. Of course, the first things about the platform is which is the jurisdiction applicable from a legal standpoint. I mean, with the big grade case was released because the jurisdiction was for sure Italian, but sometimes you don't know where the platform is. So you don't know which is the relevant jurisdiction and which court has the jurisdiction over the matter. Another topic that was raised during the pre-bankruptcy case. So we were the creditors in this case, in the case of the of Flores, of the big grade case, that was the public prosecutor, and some creditors were claiming, were asking basically for the declaration of bankruptcy of the company. So another topic which is really interesting is whether you have to size the assets immediately or not. This is a main topic because, of course, if there is there is the chance that the assets are disposed by the company during the pre-bankruptcy state, when generally there is not, the debtor is still in possession. Of course, there is a problem. In the big grade case, there was a sizer of the assets, and was appointed as special trustee for the time of the pre-bankruptcy case. So basically these assets were sized before the bankruptcy declaration, but this cannot be the case in any circumstance. For instance, I read on a newspaper that with Derop Trading, which I don't know at this time whether it will be declared insolvent or not, because the pre-bankruptcy hearing is the 4th of April, they sized the assets. So basically the Guardia di Finanza Italiana sized the assets. So probably the assets will be available for creditors should the company turn insolvent, be declared insolvent after the 4th of April. But this is a very important thing, because if the assets are disposed by the company during the pre-bankruptcy phase, there is the chance that you can't, the bankruptcy is empty. So this was essential. In our case, the owner of the company was working with the trustee to secure the assets. At least he provided help in doing that. Of course, you must have a fabulous technician helping you in doing these things, because as a lawyer, we don't know for sure. And for sure, I didn't know at the time I was appointed anything about sizing Bitcoin and or other cryptocurrency, because the big grade case, there were a lot of cryptocurrency, and there were not just Bitcoin, which was the only cryptocurrency that had the Mt. Gox, for instance. So the more Bitcoin, the more cryptocurrency, different cryptocurrency you have in the platform, the more difficult it is to first of all to manage them, and after to sell them in the market, and or to give them back to creditors. And I'll explain you why in a few seconds. So in our case, there were a lot of cryptocurrency, so different method of sizing them. Nobody has done that in the past, so it was really difficult. And fortunately, I had a great technician, which is Paolo D'Archecco, one of the most expert technician in Europe with respect to this kind of expertise. And so we had to do very we have to use various form of the of sizing technique. We have to employ some of them, because for all the cryptocurrency, they have a different way of being transferred from one side to the other. So this is very difficult. So this just to begin with respect to the pre-bankruptcy phase. After the bankruptcy, after the bankruptcy declaration, some of the topics which are relevant in a pre-bankruptcy phase becomes irrelevant. For instance, what is the jurisdiction? But some others become very important, like who owns the assets of the crypto. Of course, there are some creditors that are willing to receive cryptocurrency back because they are willing to bet over the market, and there are some others that prefers to have fiat because they want to get out from the market. So of course these topics are still relevant after the bankruptcy declaration. And but let's talk about what a trustee should do, because as a lawyer you have to do some things. As a trustee, which is something that I could talk about, you have to do other things. So basically, like in any bankruptcy procedure, you have to do two things. You have to determine what are the liabilities of the company, and you have to basically, if you haven't sized the assets in the pre-bankruptcy phase, you have to do it now, and you have to secure them and to decide what to do with them. So you have to manage them, which is really difficult. So both topics are extremely complicated because from a legal standpoint, let's talk about determining the amount of liabilities. It depends how the platform work, and everything changed. For instance, the Big Grail case, we did have a database with the name of the creditors and their email address, but we didn't know anything else about them. So and some of them could have provided fake name, as many have done, and we realized that after when we basically we made the stato passivo. So we received their claim. We asked them to identify themselves, and we found out that some of them have been registered with fake name. So what is interesting in this part from a legal standpoint is the fact that bankruptcy law provision are taught for the average company, which basically have all this kind of client or supplier, and they are basically identified by themselves. They have invoices, they have all this kind of documents that basically enable you to identify them very easily. Whereas with a platform with a platform, especially before 2018, when AML rules didn't apply to all European companies, so the identification was left basically in the discretion or to the owner of the bankrupt platform, basically. So you didn't have any information on this. So this was really difficult at the beginning because we didn't know how to proceed. We had to send them multiple emails because the email address was the only things we had at the time. So asking for creditors to provide to file their claim as it is done in any bankruptcy procedure. The problem was that filing the claim by following standard Italian law rule would have made all the claim basically inadmissible, or at least the claim completely ungrounded, because in order for a claim to be allowed under Italian law, basically you have to prove your credit, and in this case, what was the hard evidence that allowed you to prove the credit? For sure, screenshot of the platform were not enough evidence, because anybody in the community could basically make a fake screenshot. So what we need was something more. And this was something very difficult to study, and we need our technician in all the phases. And at some point, we understood that creditors, by filing claim by themselves, would have not been able to prove their claim. So we decided to build up a platform which enabled them to put their credential used in the Big Rail website, and so to identify themselves. Some of them used basically a two-phase recognition with the OTP on their mobile, and so by providing this information to the platform that was set up by the bankruptcy trustee, they were able to identify themselves and show that they were the owner of the account in the platform. This was something very important to them, I guess, because without it, I think that the court would have should have been forced to strike out all the claims. So this is a real big problem, because of course, Italian law didn't provide anything about that. So we had to do it, and we think that we have done it because, and it was right to do that, because we had to provide creditors with the mean to show the fact that they were creditors of the company without putting too much burden on them. Don't know how it happened with respect to empty box. So I don't know with different cases how it worked, but in our case, it worked very well. Of course, we had to build from scratch a platform, which was not really easy, because platform is 0-1, whereas the Italian bankruptcy law is subject to interpretation. Therefore, it was really difficult to build up everything, and it's very difficult also to build up everything and not going back because you forget something. Because at some point, if emerge a problem of interpretation and you have already made all the structure, and you are modifying part of the previous structure on the system, it can the program could have some defects. So therefore, it was really important to go step by step, and it took a lot of time to us. I think that it was crucial for us to do that anyway, because with that platform, thousands of creditors were able to claim against the bankruptcy procedure, and we were sure that they were the owner of the assets, because either they provided the information they gave to the platform, or they were able to sign the blockchain through which they transfer the crypto into the platform. So if they were able to sign it, I don't know how to do it, but basically, if we were told by our technician that only the person that used the address of in the blockchain was able to sign it and prove his identity. So there was a double way of basically of showing that you are that they were the owner of these assets. Another big problem in determining the liability was the fact that some creditors were willing to receive crypto and not fiat, and they were saying basically, please give me back crypto. I'm sure this crypto are on the platform. In the Big Rail case, for instance, the problem with the hack was just with one crypto. That was the nano cryptocurrency, and therefore the motive was this one. I had Bitcoin in the company, therefore Bitcoin are still there. Just nano got hacked, and therefore I have to receive back all my Bitcoin. This is an argument that the court didn't buy, because basically one got Bitcoin after exchanging nano. So basically, since the hack was made, the hack basically hit everybody. So possibly if I put nano in there, then the nano disappear, and I got Bitcoin. I basically gave somebody something that didn't exist. So it wasn't right to prevent them to. It wasn't right to prevent to have some people collecting 100% and some other people not collecting anything. It would have been completely unfair, and for people that in good faith believed that the assets were there, whereas maybe they were not. So So basically, the court decided that everybody should receive fiat and should receive fiat based on the value of the assets at the date of the bankruptcy procedure. And no, actually, there were the big great case were two bankruptcy procedures that were linked to each other. I don't want to go into detail into that, but basically, the court recognized a more favorable criteria to evaluate the crypto assets held into the company, and therefore we gave them the fiat value of the cryptocurrency held into the company. This just for the a bit of information with respect to determining liabilities. I think I'm over with my time, but I want to say two things with the assets. Once you have the assets, you have to realize it. In order to realize the assets, it's very complicated because you have a market that is going every day, and bankruptcy trustees are not trader, and therefore they should follow the rules of the bankruptcy procedure in order to sell the assets. So they have to be sure to take the money before the transfer is made, and respect all AML provision, and be sure that the transfer is made with the money that comes from the sale is recovered by 100% by the procedure. So if you don't follow this rule, you have a problem. So this is a big issue. For instance, Mt. Gox used Kraken to sell all his assets. I don't know how they make it, but at some point they were selling Bitcoin, and the Bitcoin was, every time they were selling, the Bitcoin was going under, was losing value. And then they used the platform to distribute the money, whereas the Court of Florence decided to distribute the money with the general provision under Italian law. We are distributing money right away. Hopefully, we'll be able to satisfy creditors in the highest percentage possible. So far, they received more than 80% of the face value of their claim, and senior creditors were paid in full, and junior creditors are being paid. Hopefully, within the year, we'll be able to make a final distribution and satisfy 100% the creditors, but let's see, because it depends from late claimants and from whether the resources are sufficient. We hope they are. So I don't know whether there is, I have more time to talk, but I think I have, my 20 minutes are over. So there is
thanks. I think I personally find it very interesting. I think it was very comprehensive for the time that you had. Are there any questions? Because otherwise I have maybe one or two. Daniele.
Well, thank you, Filippo. First of all, thank you, Tommaso, for your presentation. My understanding is that you are a pioneer for Italy in this field, and that's I believe that's a strong credit for you. And when I was hearing your presentation, just a quick questions appeared in my mind, and that's it. I would like to know if you, as a trustee, if you experience the need to bring a clawback actions, and more specifically, if there have been some sums disappeared from the wallet of the platform after your appointment as a trustee. I think that this could be a very interesting topic, because the clawback action would have as object crypto, and so all the problems related regarding the enforcement of a decision on the actions, all the things that go with that.
Actually, we thank you for your question, which is really a tough one. Fortunately, we didn't have to do any, but I can just imagine, while you were asking, I can just imagine the difficulties of doing something like that. Consider of doing a clawback action against a person that you don't know, and you don't know where it is, and you don't know whether she was the one that took the assets, because the only evidence you have is just an entry on your database. And of course, the database doesn't reflect what is in the blockchain. I mean, when crypto goes out from the platforms, from the hot wallet to the wallet of the people that took the money out, probably there will be some evidence in this respect. But how do you know that that person or the wallet? So I would see a lot of problem in that. Fortunately, we didn't have to do that. Don't even know whether we had the power, the evidence in order to do something like that. But fortunately, we didn't have to do any clawback action. So it's a topic that we didn't explore. We did explore many others, but not this one.
Thank you. I think just to give you an example, I think that every one of us knows that there are rumors that the founder of the FTX exchange, Sam Bankman-Fried, is moving funds while there is a bankruptcy pending in the United States. So this is the fact that give me
I don't know how it works in the United States, but I guess that they are like the rules there are a little bit strict. In Italy, something like this would be for sure a bankrupt, fraudulent bankruptcy, and they would bring you 10 years of prison right away. In the United States, where they are more severe with respect to this, so I don't know how they would treat him. Maybe he's willing to bet in the sense that there is a moral hazard incentive, in the sense that if he thinks that he is losing everything, maybe he's trying his last coup in order to get something out of it.
Very good. I have a follow-up question, but I will not ask it because I think it'd be very difficult for you to answer, and so I'll ask a different one.
Ahead.
Unless
maybe I'll say no comment.
But I would first check if there's any other question from the others that are connected. No? Okay. So two different things, so that you can pick and choose the one that you prefer. The first one, your comment about not your key, not your money. I think it's very, very much related to the structure of the exchange. So if you have a pure custodian, which is just, of course, acting as ledger, so what you do, you allow users to transact very quickly. You don't really involve the blockchain. I mean, there's not much which is recorded on the blockchain, and the blockchain is called in only when you actually withdraw the money from the exchange. So the question here is whether that was the case, and whether you think that it'd be different if you had, for instance, a decentralized exchange where transactions happen differently. And the other question is more of a follow-up question to what Daniele asked before. And since there was an hack, I was wondering whether you had to do something about trying to trace where the cryptocurrencies went, and whether you could, in fact, retrieve some of that, or you had some investigation activity going on in that regard.
Okay, with the second one, I can answer only this, that there was, of course, an investigation activity. It was done on our part. It was done by the public prosecutor, and this is going to be discussed in court, so I will stop here. With respect to the first part, the first question, it's true that what you're saying is true. The sentence, not your key, not your money, depends basically on the platform and how it's structured. For instance, I would imagine that the court would have been more in difficulty whether if the big grade bankrupts didn't provide for for it to use the assets of the users, of the creditors. Like if they were not just put, everything was not put just into single wallet, the hot wallet, the old cold wallet, and they were maintained in 7 different wallets, which could be used just by the creditors. I don't know what would have happened. I mean, probably the decision would have been more difficult than what it has been. In our case, it was easy because there were hot wallet and cold wallet, so everything was put inside, and the owner and and basically were used by the company to satisfy the request of each one of the creditors when they wanted to take out money from the platform. And therefore, for the court, was easy. But it's true that I think we should see the structure of the platform. Not every platform is the same one. So, and of course, Italian law provides like this, but maybe another law from another European country also could provide something different, and so the solution would have been different under the law of another EU country, despite the fact that the law are very similar.
Yeah, I think you make a very interesting point, especially in light of the upcoming MiCA regulation, which will provide, at least in Europe, for the segregation of assets. So it will not be possible to have just one wallet or one account for both the company's money and the client's money. It will need to be segregated, and possibly also for different clients. So it's going to change, and regulation will definitely play a role in that part.
Yeah, I think it would be very interesting to see how they would develop the structure of their company, because more and more basically the regulation is making this platform similar to financial institution, basically. So the segregation of assets is something we see just with the insurance companies and financial institutions. So we don't see for other companies, except for some other rules, but some special provision like finanziamenti, fondo particolare. So, but it's something really that finanziamenti destinati. It's something really interesting in this respect, how the regulation are shaping the structure of these companies. I don't know whether these regulations are coming too late, but
we'll see.
Yeah.
Well, okay. I think time is running out, and it was really good to have you. Yes.
I like briefly. I have a question, and I'd like to say something first. It was really a pleasure to hear you speak and see something very similar happening in other countries that is about to happen in Brazil. In Brazil, we are about to face 2 bankruptcies in exchanges, but not regular exchanges, but rather Ponzi schemes acted like exchanges. And I myself am acting on behalf of creditors in one of them that is called rental coins. They alleged that they would rent your Bitcoin and pay from 5 to 15% per month. I represent around, if we trade the currency, 50 million euros, around that.
Oof.
And the total amount that they have stolen from clients is around 500 million euros. It's quite a lot.
It's a lot.
And another case that is even bigger, that is called gas, not from Ether, it's only the initials of the founder. The scheme gathered over $2 billion US dollars or euros. So there are huge amounts, and the bankruptcy is just beginning, and we can't even think of the issues that we are going to face. How are the creditors going to be rated? How are their credit going to be considered? Only the money that they entered into the scheme, subtracted by the eventual withdrawals or not, or if they are going to be considered with the crazy returns of 10% per month. So I don't think that there were any of those issues in BitGrail, as it was only an exchange.
Yeah. Yeah, no, there was not the classic Ponzi scheme structure. I mean, as far as I know, there was not this, so we didn't have to face this kind of problem. But of course, I could see that there are a lot of problems. First of all, is to recover the assets that have been wiped away, because this one would be very difficult to recover them, especially if they have been transferred to wallet outside your control. For instance, so it could happen that maybe you could see the wallet where they ended up, because then everything is traced with respect to the blockchain. Trace everything, but you see the wallet and you cannot put your hands over it. So it would be even worse, possibly.
For now, because
that is my question. How have you, two questions actually, very brief ones. The first is, who were the priority creditors? Banks, governments, employees, or something different?
Yeah, there were some professional and senior creditors were professional and tax for small amounts, for really small amounts of taxes to be paid. But it was not significant. It was overall, because there are two twin bankruptcy procedures linked one to each other, it would be 50K overall at the most. So no more than that.
And the second, how have you managed to find, if there were any, I'm not very into the case, I don't know many facts about it, but to find crypto assets? Do you use some crypto company that search assets like Chainalysis, for instance, or other? Was it the police only, the trustee yourself search for these assets, or creditors presented reports on the tracing assets? How this did that develop?
In this case, the assets that were available to the bankruptcy procedure were sized during the pre-bankruptcy phase. Some of them have been given freely by given. Have been sorry, it's not the right word. Have been delivered by the company itself. So these were the main assets. Other assets were held in banks. So it was or in other platform that were holding these assets. So these one were recovered easily.
I see. No, thank you.
No, it would be very difficult to go and trace the assets all over the world, wherever they are. So because sometimes you don't know. You see the wallet, but you don't know whether they are yours or not, or maybe you know and you cannot put your hands over there.
Precisely. That's a big problem that we face. It's very costly to search, to hire programs such as Chainalysis that cost around 30K per year. And if you find something, you don't know that if you're going to be able to put your hands on it.
Yeah, but at least if you trace everything, then you know that there was something that didn't go. You can ask the people that were basically organizing the Ponzi scheme what happened to these funds. Let's say for the explanation. Maybe they won't provide any. Okay, it's not sufficient for a civil recovery of the assets, but maybe it's something that can be used to our purposes.
Thank you.
You're welcome.
Just a very quick comment on your discussion, which I found very interesting. So in BitGrail, there was a court appointed expert. So of course they had, but I guess that since it's very expensive to have experts in this field, it should be borne by the bankruptcy. It shouldn't be the single creditors that have to pay for that. It's just my opinion. And as far as recovering the assets, I think I don't know if you followed, but there are some very controversial attempts of putting liability on the developers that should change the code, so provide updates of the software. I think that's being done for Satoshi's Vision and possibly other blockchains as well. So you have some softwares that allow for the freezing and actual recovery of assets on the blockchain if you have a court order that entitles you to receiving the funds. So I think that there is a real movement there. Whether or not it's technically possible, whether or not it's in the spirit of the blockchain and it's also something that is desirable, that is a totally different question, which I don't think we have the time now to address, but definitely an interesting one, I think.
Yeah, for sure would be something that put right cases like the one of Bernardo, because in that case it would be desirable to have something like this for sure, because it's just a Ponzi scheme. It's a fraud to the average person that gets there. So if it's true what it's written in Satoshi manifest at the beginning, that manifesto at the beginning, that there will be a world without basically banks, and there should be rules that will allow people that have been frauded to recover the assets. Maybe, I don't know. It's
yeah,
because the problem is always for the small creditors. I mean, for the average creditors, average user of cryptocurrency that is stuck in a situation that is bigger than him. So.
Okay, well, that was very interesting. There is a recording, so other people will have the benefit of the conversation as well. And well, thank you very much to Tommaso and everyone who attended.
Thanks a lot.
Thank you.
Bye. Ciao.